So divorce, just as marriage is governed by the Marriage Act of 2014, and divorce is basically the legal dissolution of a valid marriage by a competent court. So you need to have a valid marriage in order for you to proceed with divorce proceedings in court. So there needs to be an actual valid marriage.
Oh, okay.
Yes. So you need to have a valid marriage in order for you to proceed with divorce proceedings in court. So there needs to be an actual valid marriage.
Oh, okay.
Yes.
On our previous episode, we discussed on the marriage and the presumption of marriage. So today we will discuss on divorce and division of matrimonial property, where Ingrid will take us through what divorce is, the elements of divorce, and what happens after divorce, and how do married couples, divide their properties. So you can take us through the divorce process in Kenya, and then we can proceed after that with the division of matrimonial property.
So divorce, just as marriage is governed by the Marriage Act of 2014, and divorce is basically the legal dissolution of a valid marriage by a competent court.
So that means that I have to be legally married.
Yes.
With those 5 steps of marriage discussed in the previous episode to go through divorce.
Yes. So you need to have a valid marriage in order for you to proceed with divorce proceedings in court. So there needs to be an actual valid marriage.
Oh, okay.
Yes.
So if my marriage is, if we cohabiting or presumed marriage, I cannot go through the divorce process?
No, you cannot.
Okay.
Right. So, unlike in many jurisdictions or in other foreign jurisdictions, where you find people go and I have to give you divorce papers to sign, or it has to be by consent, it's very different in the Kenyan legal system. Our legal system, when it comes to divorce, is a bit more fault-based, if I may say. So, in order for you to get a divorce, you cannot do it by consent. So, you cannot sit down, the both of you, and decide, oh, wow, I'm tired of this marriage, and now, let's go get divorced. We have agreed, let's go to get divorced. So in order for you to start these proceedings, either of the parties files a divorce petition in court, and then your advocate will also file something we call a notice to appear, and this is filed, and then it's served on the other spouse. And then the other spouse has 15 days within which to respond. So you can, if you're not contesting it, you can opt not to respond. If you are contesting to the marriage, or maybe there are issues or facts that have been raised in the divorce petition, then you are free to put in your response. Right?
Okay. So you can contest? And
Yes.
You can choose not to contest?
You can contest, but if you're agreeable to it, you can choose not to put in a response. The only thing that you cannot do is both of you come to court together and say, we have both agreed that we are filing for a divorce.
So what are some of the grounds then do I need to prove to be granted that divorce?
Right. So as you're drafting your petition, of course, you'll give a brief history of your marriage, and you'll give a brief history of the facts. And then now you need to establish what grounds you are relying on. So some of the grounds, the common one being adultery, we have cruelty, and cruelty can either be mental or physical, and it doesn't necessarily have to be on you as a spouse. It can be cruelty to the children as well. We have irretrievable breakdown of the marriage. We have desertion, or as many people say, ghosting. So maybe your spouse, they just packed up one day and left, and you've never heard from them for 5-6 years, and there is no prescribed time period for which your spouse needs to have deserted you. So there's no prescribed, for example, they need to have deserted you for 1 year or 3 years. And then another ground is exceptional depravity. So exceptional depravity can arise, for example, in a situation where you're a stay-at-home mom or you're a stay-at-home husband, you're the one who's taking care of the kids, and you're relying on your husband to give you financial support. And your spouse decides, I'm not going to give you money, I'm not going to support you. So you find yourself in an awkward situation, you're not able to help in management of the home, you're not able to take care of yourself. So that's something we call exceptional depravity.
Okay, so what happens if one partner decides to go to court and get a divorce and the other one says, no, I don't want a divorce? Can the court then ask the parties to go and mediate or go talk and
Yes.
come back? What happens?
So actually, before you even start the divorce proceedings, it's usually recommended that the parties at least sit down and try to have, a bit of mediation or counseling, because sometimes you find it's an issue that has arisen that the parties are able to sit down and discuss and agree and perhaps now opt to continue with the marriage. And it happens a lot. And as advocates, I think we see that a lot. You can get a client and they tell you they want a divorce, and halfway through the process, they tell you, oh, now we've decided we're getting back together.
Yes.
So in the instance that the petition is already filed in court, the court usually, yes, they can recommend, if one party is saying, no, I'm not ready to get a divorce, or I don't want to get a divorce, then the court will look at the circumstances of the case. We look at the grounds. Of course, if we have things like physical abuse, then they can't force you to stay in an abusive marriage. Yes, but if the facts are or in the court's opinion, it's something that the parties can sit down and discuss and agree, then they can refer you to mediation.
Maybe next time we'll discuss about mediation in Kenya in terms of family and even business.
Right.
Resolution.
It's actually a good option. People think litigation and court is the only dispute resolution mechanism, but we have mediation, we have arbitration.
Okay.
Even negotiation.
Yeah. Two parties. So, okay, fine. We've gone. We have petitioned. We have gotten the grounds for divorce. Then what happens next? What happens to the properties that I have invested with my partner? How do we divide? And children as well. What happens to the children?
So before you get into dividing your matrimonial property and deciding who keeps the child or who rather has custody of the child and maintenance of the child, you need to first finish on the divorce process.
Okay.
So once the court you've gone through the entire process, you've done the hearing, the court will issue you with a decree. So the first decree is usually a decree nisi, and it's valid for 30 days. And the reason why there's a 30-day period is just in case maybe the parties, they go back and they see it, just like I said, and you decide, no, I don't want to go through with this divorce. At that point, you are free to go back to court and tell the court that we have actually sat down and sorted out our differences, and we have agreed that we want to remain in this marriage and we're no longer willing to proceed with the divorce. And that is okay. If you have agreed and you set and you've said, yes, I'm proceeding with this divorce, then after the 30 days, the court will issue you with something we call a decree absolute, which is the final decree that now declares in finality that you are divorced. So after you've finished that process, then now you go back to court and file for a matrimonial property cause.
So now I have the decree absolute. We have properties. We have the home that we live. We have businesses, vehicles. Now, how do I approach the court to show that we need to divide this property? Can I claim all this property to myself, and what will my partner say?
So after you've finished with the divorce process, then now you need to move the court afresh and file for a matrimonial cause. So in this cause is where now the court will determine what is matrimonial property and how that property is to be divided. And the court is usually guided by the Matrimonial Act of 2013.